Top of the stack. After Wisconsin Governor Scott Walker enacted a law prohibiting collective bargaining for most public employees, a judge in Dane County, Wisconsin, now says it's unconstitutional. Joining me now is Fox News senior judicial analyst Andrew Napolitano. So, Judge, we've got all these constitutional arguments going on. Let's start with Wisconsin. So this Dane County judge says it's out. The people voted for Scott Walker. The legislature voted for this law. Of course the people's voice counts, doesn't it?
And he survived a recall and survived it overwhelmingly. And the essence of the recall was over collective bargaining. Look, the judge has found some constitutional obstacles in the Wisconsin Constitution. Whether he's motivated by a value set that generally supports unions, whether he's motivated by strict fidelity to the Constitution, I don't think we'll know. I do expect that this decision invalidating the Wisconsin law will be overturned by the Wisconsin Supreme Court. But there is an interesting kink here, and in the armor. One of the objections that the judge found was this doesn't apply to everybody. This does not apply. This does not invalidate collective bargaining for all public unions. It involves it for all public unions except police and fire.
Right.
Now, the Wisconsin Constitution and the federal Constitution have something called an Equal Protection Clause, which basically means you must treat similarly situated people or groups in a similar way. So how can you say to cops and fire, we'll recognize your right to bargain collectively, but to EMS and sanitation and teachers, we won't recognize your right? That's the conundrum that the Wisconsin Supreme Court will have to wrestle with, and that's the conundrum that this Dane County judge articulated in his opinion.
Let's bring it down the road. And the court and the Wisconsin Supreme Court, which is another whole part of this story, says, yeah, you got to have equal protection. Can't the legislature go right back in and say, fine, cops and firefighters, you too can't have collective bargaining?
Well, if they had the courage of their convictions, they would, and they could. But this was a rational and, as Bill Buckley might have said, elegantly wrought compromise. In other words, it was necessary to get some votes that the police and fire be exempted from this, because God forbid that certain legislators should want to treat the cops and the firemen the way they treat everybody else. There might be adverse political consequences.
Well, and they tried that in Ohio.
Yes.
And they did say everybody, cops, firefighters, every public employee, and the people went in and said, we don't like that.
In a stinging rebuke for our former colleague, now the governor of Ohio, John Kasich, it was invalidated.
Yeah.
Then, as you mentioned, Michigan, in which there's an effort to put on the legislature a constitutional amendment that'll prohibit a present or future governor or legislature from ever addressing this, because it'll become a constitutional right specifically articulated in the Michigan Constitution.
That's the question. Can you do that? Can you say from here on out no elected representative can change this constitutional amendment?
Yes, you can do that. That, of course, would require another constitutional amendment if, let's say, this thing in Michigan passes, and collective bargaining is a right enjoyed by all public employees in Michigan articulated in the Constitution. That could not be interfered with by a court. It could not be interfered with by a future governor or legislature. It could only be done away with by a future amendment to the Constitution, meaning a referendum in November.
Forgive me, but I've seen these constitutional amendments that the people, the amateur lawmakers, have voted for in various states where they have propositions and initiatives, and later on a judge comes along and says the constitutional amendment is not constitutional.
That would be very, very difficult for a court to find. But I will tell you this. The U.S. Constitution, 22, 23 pages. Some state constitutions are over 400 pages because they are filled with very, very minute principles of law that political groups wanted to enshrine in the Constitution so that the legislature couldn't interfere with it. So don't be surprised if this thing passes in November in Michigan, only to be undone in November in Michigan 3 or 4 years from now when they realize how costly it is for labor unions to negotiate across the table with people they've elected to office.
And the latest polls are it's slightly a larger group in favor of saying, yeah, we want a constitutional amendment to allow anybody to collective bargain to join a union. But it's like 39%, 36% against it, but there's a 23% undecided, a huge undecided. So we don't know how this thing's going to turn out.
Right. We don't know how it's going to turn out. We do know that there is a crazy entity in Michigan, right outside of Detroit, called Government Motors, which has financed the company and which is the company's principal client.
Yeah.
The federal government and General Motors, of course, of which I speak.
Yeah, which is another whole story about GM. We'll get to that later.
Right, but we know how those employees are going to vote.
Well, let me go back to Wisconsin for a minute, because the Wisconsin Supreme Court, that was also, a lot of people outside of Wisconsin don't realize, that was another big part of the anti-Scott Walker movement. They were also had a vote for their Supreme Court justices. There was 2 judges, one who was pro-left, one that was pro-right. The pro-right guy won, which balanced, the tip of the balance for that court is to the right.
Now, the Supreme Court of Wisconsin has already ruled on this, but it ruled on the timing of the filing of the lawsuit in favor of Governor Walker and upholding the legislation. It didn't rule on the substance of the legislation, which it will probably be forced to rule on now. And very interesting, the Attorney General of Wisconsin says he wants to enforce the legislation while it's being appealed. That cannot be done. A declaration of unconstitutionality invalidates the legislation from the beginning. However, unless they're negotiating a contract, there's nothing to be enforced. This is not legislation that's enforced on a daily basis. It only comes into existence when a collectively bargained for contract expires and it's time to negotiate a new one.
And this isn't one of those rules or laws that, gets debated and then just kind of drifts off. They've had demonstrable, measurable success in school districts and other government agencies around the state where they've saved money, increased the number of teachers that they've hired. It seems like people are pretty happy with it.
It seems like this was the right thing to do for the majority to do, that collective bargaining is not a natural right like speech or privacy or travel or religion. It's a privilege that the government can decide to give to certain groups and take away. And as long as the government does it fairly, the courts shouldn't be getting involved.
All right. We'll find out.
We shall.
Judge, thank you. Always good to see you.
Pleasure, Tom.